So, Mr. Smith, we're going to start with you first.
Thank you, Madam Chair. My name is Patrick Smith, and I'm the president of the Intellectual Property Institute of Canada. So first, I want to start by thanking you for the invite to IPIC to present to you our recommendations for IP policies that can help the value-added food sector be more competitive in global markets. As you may know, IPIC is the Canadian Professional Association of Patent Agents, Trademark Agents, and lawyers practicing in intellectual property, sometimes referred to as IP. IPIC is pleased that this committee recognizes that intellectual property is a key component to ensuring that the Canadian value-added foods industry is competitive in global markets. IPIC often speaks to government in various forums about recognizing the importance of IP at every stage in the life cycle of a business's growth, and therefore its importance to driving Canada's economic growth. Many of our major trading partners also recognize the importance of IP to business, and they are acting on that through the creation of policy incentives that reward the creation, protection, and leveraging of intellectual property. Before setting out IPIC's recommendations on policy initiatives, it may be useful to outline how various IP rights are used at various levels in the value-added food chain. IP rights are generally thought to encompass patents, trademarks, and copyrights, and are used by various food industries to protect technology or technological innovations, branding, and design. Patents can be used to protect innovative genetically modified or traditionally crossbred plants with beneficial properties. Patents can also be used to protect innovative chemical compositions of food or for improved methods or equipment used in food processing. Patent protection helps in recovering investment in research and development, as well as in generating income opportunities in Canada and abroad. Labeling and packaging are important marketing tools, and trademarks and copyrights can be used to protect these brands and designs. IPIC's members work with a variety of businesses on all these issues. With that construct set out, I'm going to turn to IPIC's recommendations, which are twofold. First is a first patent program, and the second is an IP box program. And these are not new proposals. In last year's Standing Committee on Finance report in preparation for Budget 2018, the FINA Committee recommended that the Government of Canada create an incentive for businesses to protect their IP by creating a first patent program. The FINA Committee also recommended the government establish incentives for IP development and commercialization through a commercialization coupon for researchers receiving federal grants and an innovation box tax incentive for businesses or for business revenue derived from commercialization of their IP. Unfortunately, these recommendations ultimately were not adopted in Budget 2018. However, IPIC still believes that the need exists for all Canadian industries, and the value-added food sector is no exception. IPIC encourages this committee to call upon the government, in your report on the study, to create financial incentives for Canadian businesses in the value-added food sector to generate and protect their IP. Many countries around the world are starting to see success from introducing an IP box tax incentive, and Canada's major trading partners are starting to notice. So here's the two recommendations from IPIC. The first is to have the IP box, and the second is the first patent program. Now, starting with the IP box, the expression IP box or innovation box comes from a checkbox on tax forms to identify revenues derived from leveraging intellectual property, and it applies a reduced tax rate for those revenues. This incentive would lower the tax burden on IP revenues, which could apply to the value-added food sector and would allow these businesses to compete more effectively in global markets. An IP tax box incentive will help spark innovation and R&D in the value-added food sector through lower corporate taxes on qualifying income. Similar programs are already offered for all industries in Quebec and Saskatchewan, and abroad in the UK, Netherlands, and early indications are that it will also be offered in the US. We also suggest the incentive not only apply to revenue derived from patents, but also for other forms of intellectual property, many of which are currently being deployed by the value-added food sectors. These include, for example, trademarks, trade dress, trade secrets, copyright, and industrial designs. Secondly, IPIC also continues to recommend that Canada introduce a rebate for startups and small businesses that take the important first step of seeking protection for their intellectual property. This can be done through a first patent program. A first patent program has existed in Quebec since 2015. The demand for this program has been so high that funds were quickly exhausted in less than a year. A similar program at the federal level will allow Canadian inventors, startups, and SMEs who are at a critical point of having developed an invention and are able to seek patent protection but may not have the resources to do so. A first patent program that is available to the value-added foods industry will ensure startups and small to medium-sized enterprises work with IP professionals to protect their initial IP and give them the confidence to build an IP strategy into their core business plan. Canada has the potential to be a leading innovator in today's advancing marketplace. We believe IP agents are at the forefront of helping us to succeed in that vision. We can continue to support the government's goals of pushing Canada forward to be leading innovators in today's competitive world economy. Thank you very much.
We have a number of senators who want to ask questions, and the list is Senator Moultais, Senator Gagne, Senator Deakin, Senator Black, Senator Dagenet, and if they haven't already asked all the brilliant questions, I may have a couple. So we'll start off with Senator Moultais.
Merci.
Thank you, Madam Chair. I have two questions, one for Mr. Smith and one for Mr. Hira. Mr. Smith, can you hear me? Mr. Smith, in our terms of reference in trying to find value added in food and agri-food for exports, Canada has signed a great number of free trade agreements with a large number of countries. In China, we're doing much more business than we did in the past. The committee went to China. In fact, we met exporters. There is an issue, however, when it comes to your domain, intellectual property. China claims that it has statutes that protect intellectual property from other countries, but the truth of the matter is that that may not be the case. They seem to keep for themselves IP from other companies, including Canadian companies. Agricultural export is on the up, and so how can we better protect our processors, our farmers and producers, our export associations for wheat, for example, when it comes to value-added products?
Yeah, that's a fairly complicated question. So let's break that apart for a little bit. Let's assume that there's an export of some type of a product, an agricultural product or a food processing product, to China. The question from a Canadian's perspective about what would happen in China and whether there would be an infringement of some Canadians' IP rights in China, right? So that's one aspect of the issue. So the bottom line is that if there is commercial activity that takes place in China, that will be governed by Chinese intellectual property laws. So that's the first thing. So patents or IPs are generally considered to be nationalistic in nature. So to the extent that there are activities that are taking place in Canada, they would be governed by Canadian IP laws. To the extent that activities are taking place in China, they would be governed by Chinese laws. Now, with respect to Chinese companies or Chinese entities taking Canadian IP rights, there's a couple of answers to that. The first thing is there are treaties and international agreements between countries. Canada's a member of that treaty. So too is China. And those treaties impose minimal, or not minimal, but they impose obligations of countries to impose certain rights for the obtaining of intellectual property rights in those countries. And so for patents, for example, and most likely your question is mostly directed to patents, no country is going to issue a patent unless the subject matter is new, useful, and unobvious, right? So to the extent that there is a public disclosure in Canada of some intellectual property right, including through the filing of a patent application by a company, that would preclude protection in China, right? That would preclude a company from basically taking those rights in China. The last piece of the puzzle is oftentimes we hear that Chinese IP laws are behind the times. And I know that when I started my career in the mid-1990s, that was absolutely the truth, that foreign companies seeking to protect IP in China would have difficulty obtaining remedies in courts or even getting their court hearings heard. That is no longer the case. Chinese intellectual property proceedings, they're the most numerous IP proceedings in the entire world. It outstrips the number of patent applications or patent cases that take place in the United States. And so Chinese companies or Chinese government, I think, recognizes the importance that IP plays in their economy. And I think they have taken strides to make sure that their IP system, as a general rule, is responsive to those concerns. Hopefully that's a helpful answer.
Merci beaucoup, Monsieur.
Thank you very much, Mr. Smith.
Merci.
Thank you, Madam Chair.
First question is to Mr. Smith, and in your presentation, you do mention that you suggest, not mention, but you suggest that the IP box incentive not only apply to revenue derived from patents, but also for other forms of intellectual property. And you mention, for example, trademarks and copyright. So I was just wondering how does providing reduced tax rate on revenue from trademarks and copyright promote innovation and research and development? I understand the patent, but trademarks and copyright, Tony the Tiger, I'm just trying to see how that would promote innovation.
It's a great question. And here's the way I think about IP rights and how they differ from other property rights. And the answer to this, I think, and the perspective that I've got will inform you about why it's so important that the Canadian companies and the government in general encourage IP rights. And here's the distinction, is that with a normal property, let's say you've got your car. If you're using your car, I can't use it. So the nature of property in and of itself is an exclusive right. It's an exclusive right. Only one person can use that property at the same time. With an IP right, it's completely different in that the owner of the right can license other people to use it. And so you've got a leveraged right in and of itself, so that the creation of that property in the first place, the IP property, allows you to leverage it and to let other people, not only in Canada, but elsewhere around the world, use that property at the same time. And that's the huge important aspect to this, is that if we can encourage Canadians to create these assets, then Canada can benefit from that leverage. So now, why would trademarks be grouped in the same category as patents? The answer is because the nature of the rights are the same thing. So if we've got a Canadian company that can develop a brand that would have utility in not only Canada but other places around the world, that provides the same leveraging potential that patents do. There's exclusive rights. It's something that is highly in demand if you can create a fantastic brand on something. And that's what we're trying to do, is encourage the creation of these rights that can leverage themselves. And that's the value added that every country in this world is seeking to encourage.
Could you give me an example of a good trademark that could have been leveraged?
Yeah, in terms of Canadian trademarks, I'm just, in terms of food, well, canola. Canola is not really it's probably more like a category of things, but the derivation of that seed, it's rapeseed oil that has been modified through traditional plant breeding methodologies to get rid of properties that prevented it from being used as a feedstock. There's a researcher at Agriculture Canada and a professor at University of Manitoba that were responsible for developing canola in the first place. That is something that has a potential or that has value around the world in terms of what canola now means to people in various countries around the world, including in Canada.
Okay. I have another question for Mr. Smith. How many questions am I allowed for now?
You're doing well. Go ahead.
Okay. In your written submission, you mentioned that the U.S. is not mentioned in the list of countries currently providing IP incentives, as they have yet to introduce the first patent program or IP box tax incentive. And you conclude that pundits may say this is because recognition of the importance of IP to business growth is already embedded in the U.S. business culture. I was wondering, how did that come about, and what could you maybe discuss non-fiscal approaches that would help us promote this culture that we have in the U.S.?
Yeah, that's a very, very interesting question, and I'm just trying to think of how to begin the answer on this. So how did the U.S. culture of innovation start? It started right at the beginning. So if you look at the organization of the United States, the first, I think we're into the Continental Congress, we're in the 1780s. The first patent statute in the United States was 1793. It's attributed to Thomas Jefferson, right? So that's how critically important that the Americans, when they broke away from England, that's how critical that they thought that the patent rights were. When you look at the origins of an inventor, businessman, and you think of Thomas Edison, and in terms of how he formed a group of researchers together to commercialize IP initiatives, right? That's probably indicative of the American sense of innovation and how important that initiative or those thoughts are to the American populace. What's different in Canada? Well, Canada had patent statutes before Canada was Canada. So Upper Canada, Lower Canada had patent statutes, and so did the province of Canada before there was a Dominion of Canada in 1867. So Canada has been has thought that patent rights are very important within that. What's different? I suppose the one thing is that there's an element of scale to Canada. So if you look at Canadian researchers, their most important market is not going to be Canada typically. It's going to be the United States. And so sometimes Canada, for various reasons, may lose its researchers to other countries. And the obvious place or the obvious landing spot for some of those researchers is going to be the United States, right? What can Canada do to foster this, to make sure that we keep research and development in Canada on a non-fiscal basis? So here's the one thing that has happened. One is the obvious thought would be, can we keep it in universities? And can we have better ties from the universities to industry, and to make sure that there's a closer relationships between those universities and businesses that can derive benefit from the research that is being conducted in universities. And various institutions in Canada. So the IP policies of the universities are largely determined on an institution by institution basis about who owns the IP, what route it has to take for those IP developments to be commercialized. And so how can Canada ensure better incentivization of research and development without a fiscal stimulus? That's a very difficult question. I'm not sure that without a fiscal stimulus, I think that activity would have already taken place. And without a bump or a push to do something differently, I think it's legitimate to think that you would have the same results that you've had in the past. So if you want to do something differently, you better do something differently, is I think the message that we're sending you.
Thank you. Thank you. And thank you very much for your presentation.
Thank you very much, Chair. Mr. Smith, I think I saw your twin brother last week on the banking committee, and he did an excellent job as you did today. So he did a great job. It was the same, one and the same, to be clear. No, I think he's claiming attribution to all of the great ideas he brought forward. I had to step out briefly during your lesson, but one of the things I was reminded about when you were talking about the history in the U.S. Patent Office was the quote in 1899 from the U.S. Commissioner of Patents, who said that everything that can be invented has now been invented, and so we're never done in this business. It's amazing. When looking at your box incentive in your first patent program, I'm really wondering about one of the areas where Canada's got some significant challenges, and that's not necessarily in the creation and protection of IP, but it's in the exploitation of it. We've got some phenomenal universities that are doing world-leading research, and we've got some great companies that actually created some phenomenal IP that was sold. You know, all of Nortel's IP was sold to BlackBerry and others, and it still hasn't been unlocked entirely. We're not as good at unlocking IP, and I really want you to sort of help me in how you see this really changing, the proposals you're putting on the table, really changing that element of the process of from creating intellectual property to protecting it to then exploiting it and creating value from it. Because that's the only point at which value is created. It's consumed during the discovery and protection process, right? It's only created once you find a way to apply that IP. So how will the two programs that you're proposing help specifically in that biggest challenge that Canada's really struggled with?
Yeah, I think that's a good question, and I don't think these proposals are specifically directed to that. It's directed to two things. The first is this patent, the first patent program. So let's start with that, because these two programs, or the incentives that we're offering, are complementary, and they're necessary, but they're directed to different activities. So the first one is the first patent program, right? So that's small and medium-sized enterprises. And the statement that you made about companies are good at recognizing IP and protecting it, I don't think that that's the experience that our members have had with respect to small companies. We do know that, looking at the research, small companies that actually do protect their IP tend to be more successful than others that do not. And so one of the things that we're looking at is trying to encourage these companies to basically consult with IP professionals and to establish some type of a program that will recognize IP, how it should be protected, and how it should be exploited. That's the first thing, and that's directed to small and medium-sized enterprises. The second incentive that we're looking at isn't really directed to trying to help companies exploit IP, although a side effect is going to have that. But the second program, in terms of the IP box, what that's really looking at is how can we encourage Canadian companies or companies basically to house their research and development in Canada. And the way that this is going to have beneficial results for Canadians is a few ways. The first thing is that if the IP is created in Canada, right, the revenues associated with the exploitation of that IP, if there is going to be any, largely are going to remain in Canada. And it's a transfer pricing type of a scenario. I don't know if the senators need me to go into that.
No,
But it's basically.
Yeah, I get that. I get
Yeah.
that process.
And so helping companies exploit their IP, that's really a different issue that our incentives are not specifically focused on that.
Yeah, I just have a bias that the exploitation side is where we've got some real limitations, more than discovery. But I mean, it's just a personal bias.
Right.
So I really like your explanation. How do you see your proposed programs interacting with, for example, the SHRED program, the SR&ED tax credit program? And because this would be then protecting IP that has been documented and recognized through the SHRED program. Do you see a way it'd be a great way to authenticate the value, like the government would see that this is valuable IP or this has been well documented in its development. So there must be some way to link the two together, but
There may be. I'm probably the wrong person to ask about
Yeah.
that. But the other thing is that that whether something is good IP or bad IP is often measured in retrospect.
yeah.
Thank you very much, Madam Chair. My first question is for Mr. Smith. Research is continuous, but on average, a patented seed discovery is protected for how many years on average?
Yes, Senator, that would be measured from the time you file an application for a patent. So it would be 20 years from that date. So basically, once you've made your invention, you'll likely prepare a patent application and file it with, it could be the Canadian Intellectual Property Office, and your clock would start running at that point in time.
In your brief, you gave a couple of examples of innovation. We might lose innovation to other countries. Could you give us examples of innovations that we may have lost to the benefit perhaps of the United States?
Well, yeah, there's all kinds. So when I went to University of Waterloo engineering school before I was a lawyer, and I remember that many of my colleagues went to work at Nortel, and I know that we didn't lose that to the United States. Nortel ceased to be in existence, but all those researchers found homes in other jurisdictions. So that's one thing. If you look at the history of Canada, some of you can go back into the 1960s with A.V. Rowe. Some of those skilled researchers went to work at NASA in the United States. If you look at university researchers in Canada, sometimes we'll attract some researchers, but oftentimes they'll go to other places. So here's the one thing that I think that everybody is talking from the same message. That what we want to do is we want to create an environment in Canada that welcomes our researchers, because these are the highest educated people we have in this country. We want them to have an environment in Canada where it makes sense that they can perform the research here. And it's not just having favorable IP laws, it's also having regulatory business laws that are favorable and flexible for those researchers. It's about having a favorable tax climate. And unless everything is in place, these highly qualified researchers have the most options of anybody in our country about where they can live and perform their research. If they're that good, they'll have choices. And what we want to do is we want to make sure that the business and research climate that we can offer is the best that we can possibly have. And I think all members of this panel are speaking from the same songbook on that message.
Puis, si maintenant on veut
If now we want to talk about funding, we often know that big industry wants to appropriate discoveries, to appropriate the benefits. Are there any smaller industries that have taken an interest in innovation? I'll give you an example. If you had money to invest, would Canada be a good idea for investing your money for innovation?
I think it's probably like all things that in terms of an investment, it's probably not done generally on a macro level. It's probably done more on a micro level. And so if somebody's investing in technology that has been developed, it's probably going to be technology specific. But here's what I can tell you is that you know the seed industry is one example here. Is that Canadians have been leading researchers in this area. And the example I gave about the development of canola is really a story about innovation and development that changed the economy of Western Canada. I'm pretty sure the gentleman can offer better statistics than me, but I think it was something like 9 million acres that were planted with feedstocks after the Second World War, when the demand for rapeseed oil as an industrial lubricant dried up. Canadian researchers basically turned around the economy of Western Canada with that innovation. And those researchers, some of those researchers, not those same researchers, but those research activities still take place in Canada. But some of the seed companies, they have their research facilities in Argentina, for example, or the United States, for example. And one of the questions is, can we make sure that if these companies are involved in these industries, can we make sure that Canada is an attractive place for those important research activities to take place here?
I have a question for Mr. Smith. You gave us 2 recommendations in your brief, and I'm wondering if you have any other recommendations, or did you feel constrained by the time?
This is what we've got on the table now. But in light of the question we got about the exploitation of IP, I'm going to take that back to IPIC, and it may not be today, but we'll come back with another recommendation at a future point.
Okay, we'd appreciate that. Just send it to the clerk, and he'll make sure we all get it. That's great.
Mr. Smith, I just want to be really clear. I'm not against the protection of IP in any way, shape, or form. Just want to be really, really clear on that one. I just know how tough it is to get any sort of tax incentives through finance, and I think there's a job to be done to show that this is going to definitely cause a net increase in companies to make money. They've got to see an ROI, and they've got to make sure that they're not just subsidizing legal fees that might otherwise be paid, that we are creating net new value. So it's just going to be a challenge necessarily on that. But do you have data? Have you done some analysis in that regard?
Yeah, we're early stage on this. We recognize that, how important it is to develop data. So the first thing is the UK is probably ahead of the rest of the pack in terms of providing these tax incentives, and the data is coming out of there. Some of it is in the paper that we presented. That's the first thing. The second thing is we recognize how important that's going to be to provide economic analysis of that, and we're in the process of starting to gather that for the government.
Good.